When it comes to protecting your finances and ensuring that your loved ones are cared for, there's no room for error. The right legal documents can make all the difference, not only in safeguarding your wealth, but also in ensuring that your wishes are respected when you're no longer around or able to make decisions. Without these crucial documents, you risk your assets being mismanaged, family disputes, or even your healthcare decisions being made by someone who doesn't know what you truly want. So how do you make sure your hard-earned wealth is protected for generations to come? It starts with understanding the top legal documents every individual should have. In this video, we'll break down the 5 essential legal documents that are critical for securing your financial future and your family's well-being. From wills and trusts to beneficiary designations and power of attorney, we'll explain how each of these documents can be a game changer in protecting your assets. Stay tuned, because if you don't have these in place, you could be leaving your family and finances vulnerable to legal pitfalls. Let's dive into the top legal documents that every responsible individual needs to have. Will, your blueprint for asset distribution. A will is one of the most essential legal documents to ensure that your assets are distributed according to your wishes after your death. Without a will, the state will decide how your assets are divided, which could lead to unexpected outcomes. A will allows you to name beneficiaries, appoint an executor to manage your estate, and even designate guardians for your minor children. If you have specific requests for your belongings, property, or investments, a will is the only legal way to ensure that these wishes are followed. Creating a will is especially important if you have dependents, as it lets you choose a guardian who will care for them if something happens to you. It also helps in minimizing family disputes, as your intentions are clearly documented. If your estate is substantial, a will can help reduce taxes by taking advantage of exemptions or deductions available at the time of death. However, a will only covers the assets in your name and doesn't protect assets held in a trust or accounts with named beneficiaries. Regularly updating your will is important to reflect life changes like marriage, the birth of children, or the acquisition of new property. Without a will, the probate process can be lengthy, costly, and emotionally draining for your loved ones. This makes having a clear, legally enforceable will essential to avoid these complications. It's recommended to work with an estate attorney to ensure your will is drafted accurately and aligns with your long-term goals. In summary, a will ensures your assets are protected and that your family is spared unnecessary confusion during a difficult time. Power of attorney. Control your finances if you're incapacitated. A power of attorney, POA, is an essential document that grants someone you trust the authority to make important financial, legal, and medical decisions on your behalf if you're unable to do so. This can happen if you're incapacitated due to illness, injury, or even old age. A durable power of attorney is particularly crucial as it remains in effect even if you become mentally incompetent or unable to make decisions for yourself. This document provides clarity and ensures that someone you trust manages your finances without needing a court-appointed guardian or conservator. There are 2 main types of POA: general and specific. A general POA grants broad powers to the agent to act on your behalf in almost all legal and financial matters, including managing investments, paying bills, and signing documents. On the other hand, a specific POA limits the agent's powers to specific tasks, such as managing your healthcare or handling certain financial transactions. A POA helps you maintain control over your assets and prevents the potential financial chaos that could arise from an emergency or sudden incapacity. Without a POA, your family may need to go through a lengthy court process to gain legal authority to handle your affairs, which can be expensive and time-consuming. Establishing a POA provides peace of mind, knowing that your financial and healthcare needs will be taken care of by someone you trust, reducing the burden on your loved ones during challenging times. Be sure to choose a reliable and responsible person as your agent and periodically review your POA as circumstances change. Trust. Protect your assets and minimize taxes. A trust is a powerful legal tool that allows you to pass your assets on to beneficiaries while avoiding the delays and costs associated with probate. When you establish a trust, you transfer ownership of your assets to the trust, and the trustee you designate manages them for the benefit of your beneficiaries. One key benefit of a trust is that assets held in the trust are not subject to the probate process, allowing for faster distribution. Unlike a will, which only becomes effective after your death, a trust can be used to manage your assets during your lifetime and distribute them upon your death. There are two main types of trusts: revocable and irrevocable. A revocable trust allows you to make changes or dissolve the trust during your lifetime, while an irrevocable trust, once established, cannot be altered. Irrevocable trusts offer greater asset protection because they remove your assets from your estate, which may protect them from creditors or lawsuits. Additionally, a trust can help minimize estate taxes by taking advantage of tax exemptions and deductions available under tax law. Creating a trust offers more control over your wealth than a simple will, especially for those with significant assets. For example, trusts can be set up to provide for minor children or family members with special needs, ensuring that the funds are used according to your wishes. While trusts offer numerous benefits, they require careful planning and should be drafted by a qualified attorney to ensure they meet legal requirements and align with your financial goals. Living Will / Advance Directive. Your healthcare wishes. A living will, also known as an advance directive, is a crucial legal document that outlines your healthcare wishes in the event that you become unable to communicate or make decisions for yourself. This document allows you to specify what types of medical treatments you want or do not want, such as life-sustaining treatments or resuscitation, in case of serious illness or injury. Having a living will ensures that your preferences are respected, regardless of whether or not you're able to communicate them at the time. Living wills are particularly important for those who want to avoid unnecessary interventions or suffering, particularly in situations where recovery is unlikely or the quality of life would be significantly compromised. It allows your family members and healthcare providers to make decisions aligned with your wishes, reducing the burden on them during what could be an emotional and stressful time. Additionally, it helps prevent any potential conflicts between family members or between you and your medical team about the course of treatment. While some people may not see the need for a living will, especially when they are young and healthy, it's wise to plan ahead. Accidents or sudden illnesses can happen at any time, and having a living will ensures that your healthcare decisions are made according to your preferences. Review and update your living will regularly to ensure it reflects any changes in your healthcare philosophy or medical condition. Beneficiary designations. Keep your assets in the right hands. Beneficiary designations are critical documents for certain assets like life insurance policies, retirement accounts, and bank accounts that allow assets to be directly passed to a designated person upon your death. Unlike a will, which covers assets in your name, beneficiary designations ensure that these assets bypass the probate process and go directly to your beneficiaries. It's essential to keep your beneficiary designations up to date to avoid confusion and ensure that the right people receive your assets. Many people fail to regularly review and update their beneficiary designations, which can lead to unintended consequences. For example, if you've gone through a divorce and haven't updated your life insurance or retirement account beneficiary, your ex-spouse may inherit those assets instead of your current partner or children. To avoid this, review your beneficiary designations after any major life event, such as marriage, divorce, or the birth of a child. In addition, it's wise to name contingent beneficiaries. These are secondary individuals who will inherit the assets if your primary beneficiary is no longer alive or able to claim them. Failing to properly designate beneficiaries can create delays, legal challenges, and potential family disputes. By keeping your designations current, you ensure that your financial legacy is carried out smoothly and according to your wishes. Now that you understand the importance of these legal documents, it's time to take action. Don't wait until it's too late. Creating or updating these documents now can save you and your loved ones from unnecessary stress, financial loss, and legal headaches down the line. Whether it's ensuring that your estate is distributed according to your wishes, protecting your healthcare decisions, or minimizing taxes, these documents provide the clarity and security you need. Remember, It's always a good idea to consult with an estate planning professional to make sure everything is in place and legally sound. If you found this video helpful, don't forget to like, share, and subscribe for more valuable legal tips and financial advice. Drop a comment below to let us know which document you found most important. And if you have any questions, feel free to ask. Take control of your financial future today and protect what matters most. Thanks for watching, and we'll see you in the next video.